when we have busy days, I should be on time. So thank you. All right. So we will go ahead and, of course, no bill request for introduction. So we'll go ahead and have our hearing on House Bill 2155. And I'll go ahead and open the hearing and ask for the bill brief from Jason Thompson, our reviser.
Thank you, Madam Chair. Good afternoon, committee. As you said, Jason Thompson, Office of Reviser of Statutes. House Bill 2155 specifies that sheriffs have liability for official acts related to charge and custody of jails. You can see there's one statute amended. It's KSA 19-811, which has not been amended in quite some time, hence the change of his and himself to more neutral terms as we've done over the last many, many years. But you'll see the main provision there is that the sheriff shall keep the jail himself or by his deputy or jailer for whose acts he and his sureties shall be liable. And the bill changes that to keep the jail personally or by a deputy or jailer for whose official acts the sheriff and sureties of the sheriff shall be liable. The key word there being official. And I note in the bill brief, and I'm sure the proponents will note this as well, the main purpose of that is to align the statute with current law in KSA 19-805, which specifically says the sheriff is liable for official acts. And that discrepancy between official acts there and simply acts here has caused some concern. So this would remedy that by adding official acts to this statute, as well as doing the other cleanup that I mentioned to bring this into the century that we're in. And I would know this would take effect on July 1st of this year if adopted. Happy to answer questions.
Okay, thank you. And did you mention when this statute was last dealt with or when it was?
I didn't. I looked a while ago, but it was early 1900s as I recall. Okay. It's been a very long time.
Yeah. Okay, thank you. Questions? Representative Carmichael and then Goddard.
Thank you, Madam Chair. Mr. Thompson, my presumption is that one of the objectives of this is to insulate or immunize a sheriff for illegal acts committed by his deputies involving people in custody. I don't know for sure if that's the case. I'm sure we'll hear more. But the hiring, firing, supervision of jailers, if you will, or jail deputies, allegations are often made that they were negligently hired or should have been fired before they committed an assault, for example. Is under this, would the sheriff still respond for his official acts in negligent hiring, for example? Or is this, will this result in immunity for anything his employees do, or even for that matter, respondeat superior? I see you pondering. I think you understand where I'm headed. Just any help you could give me would be appreciated.
Madam Chair, Representative, it's maybe a little too complex for me to process with the bills I'm processing right now. This is a confined statute about liability for official acts. I'm aware of the general respondeat superior, all the other negligence concepts. I think they can all interact together and operate just as they are now, but let me ponder that a little bit more.
Well, that's the best expression of legislative intent we can come up with. I appreciate it, sir.
Representative Goddard.
Thank you, Madam Chair. As I understand this, if the sheriff or the jailer committed an illegal act, that would be treated differently than an official act that would be covered by liability insurance, etc.
Madam Chair, Representative, yes, generally in the law, there are certain liabilities for official acts and certain liabilities for illegal acts, and they're treated differently. And I think the point of this is to align this one with the other statute where they're currently only liable for official acts. And so, yes, I believe that is part of the point.
Thank you very much. Thank you, Madam Chair.
Yep. Any other questions, committee? Okay, thank you, Jason. Okay, we'll now have Sheriff Jeff Easter from Sedgwick County come up as our only proponent, as our only, anyone today, any comfrey at all. Welcome. I hope you're feeling better. I know the other day you were under the weather, so I hope you're feeling better. Yeah. Mhm.
Turn on the button. Appreciate you giving me the time today to come up and speak to you, and I'll answer a couple of questions that were asked earlier. As he pointed out, there is a difference between 19805, which talks about official acts, and 19811, which does not talk about official acts. These laws were drafted in 1868, have not been updated since. There is also 3 court cases that's also in my written testimony. Hitzman versus Kennedy, 1933, another case in 1956, and another case in 1997. 1977, that have ruled upon that it should be for official acts that our sureties and bonds are responsible for. So we're wanting to align those two because they are not aligned. To the question that Representative Carmichael asked, can we still be sued for this stuff that you talked about? Absolutely, and I still am getting sued. And so it doesn't shield us from the particular lawsuits, especially when you're talking about negligent claims of training, negligent claims on hiring, those type of things. That's an official act that I took. And so what it does is it aligns the statutes together for unofficial acts, such as receiving sex from an inmate. That is an unofficial act. Those people are fired, charged, and went to prison. That's how that should be handled. And so that doesn't mean that people can't still sue us for those acts, though. And then it takes a jury or a judge to determine whether or not it fits these statutes and whether or not we are liable for those unofficial acts. And so it does not stop any civil process in any of this. That's about all I got.
Okay. Yep. And now we'll take questions if you're okay with that.
Absolutely, yes,
Okay,
ma'am.
that's great. Representative Lewis.
Thank you, Chairwoman, and thank you for coming. Just on your last point, I just wanted to make clear, the jury would be instructed that if they find it to be an unofficial or not an official act, then they would have to find no liability. That's the point. You have to be engaged in an official act to be sued in your official capacity.
Well, so I just went through this on a lawsuit. And in the federal trial, it is much different than in a state torts claim. And so this was debated by the attorneys representing the sheriff's office and attorneys representing the plaintiff. And that was one of the questions the federal judge had, was because one statute said one thing, the other said nothing. Either way, the jury could have ruled whether this says this or not to award the plaintiff money from the county, just not from my bond, if that makes sense. And so in that particular case, they didn't award her anything. And it's a long case, but my belief is it does not shield sheriff's offices from being sued and actually being liable. But it does clean up the language for judges to understand which statute applies.
Okay, one follow-up. So in your example about one of your jailers having sex with the inmate, as you said, that jailer would be fired. And I presume the lawsuit, if there were any against the sheriff in charge of that, was that they somehow engaged in negligent hiring or supervision, that training to that eventually was proximate cause. The argument would be proximate cause of that, and that would be how you would get sued in that circumstance for your official acts.
And a civil rights violation, yes, sir.
Okay, thank you.
Okay, other questions? Representative Carmichael.
Thank you, Madam Chair. Sheriff, I think we're on the same track here. Okay. it looks to me like part of the problem that sheriffs confront is what is the extent of the liability on the bond, as opposed to liability that may arise out of negligent training or retention of employees when sheriff knew or should have known that they were unsuitable or unfit. It looks to me like the intent here is to make the bond pretty strict as to what it applies to. Whereas I think you're saying that an injured plaintiff could still perhaps look to the Kansas Tort Claims Act, the county's insurance policy, but not the sheriff's bond. Is that where you're headed here? Help me.
Yes, that is part of it because of what 19805 says, which is for official acts. And so, yes, we're simply wanting it to state the same thing because there is, I know the federal judge is still pondering this particular issue because of the way it is written. So yes, I would agree with your statement, sir.
My second question, with your leave, Madam Chair. The other thing is I don't want us to leave here with the impression that all of these cases are just up to the jury and the jury depends on how they feel on a given day. The court, as I'm sure you know, has an opportunity to consider motions for summary judgment and dismiss cases where the sheriff doesn't have liability as a matter of law before a trial, or even after a trial and a verdict arises, there are motions for a new trial, motions to set aside verdicts, and even appeals.
That's
I think you fully understand it's just not up to the whim of the jury to walk
No.
in one day and say, yeah, I think we're going to hold Jeff Easter liable, but the sheriff in Osage
But it
County is a
can
nice
happen that
feller.
way, though. It can happen if it goes to jury trial and a jury makes a decision. So it can happen that way. But there's a lot of technicalities that take place before then, before it ends up in trial. So yes, sir.
That was my two questions, Madam Chair. Thank you.
Committee, any other questions for Sheriff Easter? Okay, we really appreciate you coming up.
Thank you for having me.
Being here with us. So it's good to see you.
Absolutely. You too.
Thank you. Is there any other proponent, opponent, or neutral testimony from anybody?
Madam Chair.
Yes. Mm-hmm.
Could I just ask your indulgence for a brief moment of privilege before the sheriff leaves?
Yes.
Yes, I thought he might have a warrant when I saw him sitting here today because yesterday I inadvertently may have suggested that I went to websites where
Yes.
depictions of underage juveniles were present. I want to make it clear that was a misstatement of fact, Sheriff. The websites that I went to were those for adults where unfortunately some of our proof and verification of adult status doesn't work. And I know the Attorney General's doing his best on that, but I want to make it clear, as far as I know, I've never been to a website where those things were displayed, and I apologize for my remarks. Thank you.
Good. Glad you're on your best behavior. So. Okay, thank you. Anyone else have a comment about this? Okay, I will close the hearing on House Bill 2155 then. Okay, committee, we're now going to have something a little different than we typically do in the Judiciary Committee, and that is an informational hearing, or it says informal in our agenda, because we have a bill coming up that completely updates our guardianship and conservatorship statutes. It's a long bill. I think I've heard like 110 pages or something along those lines. And so it's just taken a long time to get the rewrite done, and especially the proofreading and so on. And so it's a big piece of legislation that we will be considering next week. We had time this week to have an informational hearing. Or actually, the same thing is actually going to happen tomorrow on another topic. But for today, we're going to have the informational hearing so that you get a bit of background about guardianship and conservatorship. You can ask questions, you can understand why the update was needed and all that kind of thing, so that when we have a hearing next week, when we maybe that same day have 3 or 4 other hearings, that we'll be able to just have the expedited hearing. And so today's your day to particularly ask questions if you have questions about why we're doing this guardianship update. So with that, I will call the Honorable Marilyn Wilder to come up and explain, if you will, why, how you happen to be the person that's here in front of us today and what the process was. And we did get some information from the Judicial Council. And so I'll just let you go ahead and give us all the background, whatever information you think we know, and then I'll let the committee ask questions. Okay, thank you for being here.
Sorry, I thought I was looking for a green light. So first of all, I'm going to say I've been on the bench for about 9 years, and so it's been a while since I've been subject to questions, so I may be a little rusty at this, but I'll give it my best. I'm Marilyn Wilder. I sit in the 9th Judicial District, which is Harvey and McPherson counties, but I sit primarily in Harvey County. I was requested in 2020 to first be on the committee looking at guardianship and conservatorship, and then was asked to chair the committee. And when I said yes, I had no idea what I was saying yes to, because again, we started meeting in 2020. We were asked by the Judicial Council to review 2 uniform acts, the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act and the Uniform Guardianship, Conservatorship, and Other Protective Proceedings Act. So 2 uniform acts, one which deals completely with jurisdiction, the other that is more comprehensive, dealing with guardianship, conservatorship, and other protective proceedings. If you're not too familiar, a guardian takes care of a person that they are then legally obligated to assure their health and well-being. A conservator takes care of a person's assets. So an individual might have a guardian, they might have a conservator, or they might have someone who acts as both, or they might have 2 different people in those roles. There are states who refer to guardian of the person and guardian of the property. Kansas doesn't do that. We use guardian and conservator. They can apply to adults with some type of impairment. And again, that is a broad range of what that impairment is. To minors who, for one reason or another, don't have living or able fit parents to care for them, or minors with impairments. At the beginning of our committee, or of our meetings, first of all, I should say that our committee was made up of social workers, lawyers, and judges who work and have practiced in this area. At the beginning, I will say there were members of the committee who thought, oh, the Kansas law is just fine. We're not really interested in making any changes. And the more we looked at the Uniform Act, we began to think, well, we could pull in some references that the Uniform Act makes, and then we eventually, instead of infusing the Kansas law with the Uniform Act, we ended up infusing the Uniform Act with Kansas law.
Judge, could I just ask you one question?
Absolutely.
Or just ask you one question to explain to the committee, what is a Uniform Act?
Thank you.
Mhm.
So there is a Uniform Law Commission that comes up with uniform acts. And so one that you might be familiar with is the Uniform Commercial Code. There are certain laws throughout the country that all states have adopted in some form or another. The Uniform Jurisdiction Act, and I won't cite it exactly, has been adopted by 46 states. And so we were very sure going forward that we wanted to adopt or recommend adoption of the Uniform Jurisdiction Act. The Uniform Guardianship, Conservatorship, and Other Protective Proceedings Act. At the time we began meeting in 2020, only 2 had adopted that act. I tried to find last night through my friend Google how many states had adopted it up to this point, and all I could get was 2014 information. So I don't have an answer as to how many states have adopted this. I will say that I'm not sure that our version will qualify as a uniform act, because we did, again, insert a lot of Kansas law into it, and we at least got some question from counsel for the Uniform Law Commission that it wasn't going to be uniform. We made some of the changes they requested, and we didn't make some of the changes they requested. Thank you, Madam Chair. Early in our process, we heard from David English, who is an expert in guardianship, conservatorship, elder law. And we were also meeting during the time a few years ago when you might remember the Free Brittany campaign. And guardianship and conservatorship laws were very much in the news because of abuses of those. So again, we have been working for about 4 years. Once we had a final draft, and I use air quotes for final, last spring we submitted that to various bar associations and stakeholders for their review and comment. We did get some review and comment. And then near the end of our process, and when I say end of the process, in effort to try to get it to legislature, we did also hear from Joan Kelly, an affiliate with the National Council on Severe Autism and president of the KNI Parent Guardianship Group from Gardner. Her concern generally was that we were making it more difficult for parents, particularly, of profoundly and severely disabled children. The law that hopefully is going to be proposed takes a more expansive view of guardianships and conservatorships and tries to cover a waterfront of situations, so that one of the aspects of the uniform law was to make things more person-centered, and rather than having a guardian or conservator use a best interest standard and kind of substitute their own judgment for what the person might have chosen, the guardian or conservator is to make decisions based upon what they think the person they're caring for would choose to do. So again, it takes away kind of some of the top-heavy, heavy-handed things that can and have happened in guardianships before. That seemed to Ms. Kelly and her group of parents that we were going to make it harder for them, because the intention then would be that even if the people they were caring for couldn't speak for themselves, that they were going to have to do a lot of work and go through kind of the motions of trying to figure out what those folks wanted. Again, that wasn't the intent, and I don't think that's how the law is written. It's if the person is able to make their wishes known, and there's some basis for knowing what those wishes were, to try to follow those. If the person can't make wishes known, and a lot of that will be determined by an examination that's actually required now at the beginning of the process. So again, we're trying to facilitate a wide range of situations. One of our committee members noted that we need to give people the freedom to make bad decisions. We, as folks without guardianships and conservatorships, sometimes make bad decisions. And so those folks within reason also need to be given the opportunity to make bad decisions. We also heard from the Disability Rights Center, Kansans for Life, Kansas Catholic Conference Center, Kansas Council on Developmental Disabilities, Big Tent Coalition, on the guardian's role in making end-of-life decisions. That law, or that part of the guardianship law, had also been in place since 2002. That's the last time any of this was reviewed. And so we took a look at it again. They asked that we require a hearing before somebody just signs off on an end-of-life decision. We said that makes sense and let's do that. They wanted that to happen within 14 days. I believe the draft has it happening within 3, just because sometimes there's some urgency to that. They also requested that there be an attorney appointed for the, we used to call them ward person subject to guardianship. And through the generosity of the Disability Rights Center being willing to take that role, we said, yes, we'll have an attorney in every case, even if the person can't afford one. They also asked that we, at the hearing, require the standard of proof to be beyond reasonable doubt. And the committee initially couldn't agree on that. When we got further feedback, the committee said, we feel like we've done as much as we can do. We have as much consensus as we can have. If there are further changes, that needs to be done by the legislature. For end-of-life issues, speaking generally on behalf of the committee, we noted that personal beliefs vary widely, religious beliefs vary widely, our understandings of what happens at end of life or how that works vary widely, and we were also concerned about prolonging suffering in some cases. I personally am aware of cases where somebody was having ribs broken every time there was an attempt at resuscitation. And so trying, again, to look at each case individually. So the new statute is much longer, as the chair stated, but we believe it's better organized. It's easier to read because the language is clearer. It does use person-centered language. So again, instead of referring to a guardian and a ward, we refer to the guardian and the person in need of guardianship. A guardianship plan is now required in every case. Current statute in Kansas says that there may be a plan. The current statute says there shall be a plan. And the idea of having that plan is that the judge and the guardian are very clear on where the person's going to live, who, if anybody, is going to be providing in-home care if that's necessary, what kind of decisions that person is going to be allowed to make, what decisions they can't make. And so there will be a plan required. There is a plan required for minors as well, which wasn't in the Uniform Act, but we thought it was important for minors as well. An actual examination is now required. We've always had to have some information from a doctor presented to the judge before a guardian or conservator could be appointed. But as our committee members pointed out, sometimes that was essentially a note on a prescription pad that said, this person needs a guardian. We want to have an examination in detail with the physician telling us why the person needs a guardian or conservator. There was an option, or we have an option in the bill for a court liaison to provide an independent report. The language that the Uniform Act used was visitor. Nobody on the committee liked that language, and so we worked quite a while to come up with the term of court liaison. Again, that's a person who might have some specialized knowledge about that particular individual's disability or impairment that can act as kind of an independent person, not the person trying to become guardian, not the person subject to guardianship, not the doctor, but somebody who would have some independent knowledge and professional expertise to make that happen. The Uniform Act required that in every case. We said we don't think we can require that because we're not sure, first of all, who those professionals are, if those professionals exist in every community, if every person subject to a guardianship has the funds to pay for that, or if it's even necessary. So we made that an optional position. There's also a greater definition of the role of an attorney appointed to the person who is subject to proceedings. So I've given you a really quick overview of our process and what you would be looking at. And if you have questions, I'll do my best to answer.
Okay, thank you so much. I think you did a good job of explaining why, what was the reason that we felt like we needed to do this rework. And just for the committee's information, last year we passed the third-party uniform visitation law in this committee. And third-party, it was like grandparent visitation in situations, if y'all remember that. And it was a modified uniform law. So we didn't exactly take what they had said, the Uniform Law Commission, but they still recognized that we had passed something. And so sometimes it's helpful. Sometimes in some areas of law, you know, we just want to do the Kansas thing, and we don't do a uniform law. But sometimes it's very helpful to know what, to have consistency across state lines and that kind of thing. So just a little more about the uniform laws. Okay, committee, what questions do you have? Representative Schreiber, you can start us off.
All right. Thank you, Judge.
Yes.
Not being an attorney, you might find this pretty easy, but so if it's a minor that needs guardianship, I think that'd be the right one. Who's all involved in that determination and the development of the plan?
So let me, Madam Chair and Representative Schreiber, let me answer the second question first. The persons involved in development of the plan would be primarily the guardian, to the extent feasible, the minor, him or herself, and the judge would have input on the plan. It would be submitted to the judge, and if the judge had questions or thought that it wasn't complete enough, or I don't know about this, then they would go back and work on the plan. As to who's involved in determining who is going to be guardian, that's probably different in every case. For probably only lawyer parents and parents who know lawyer parents, when you have young children, you have the opportunity in your will or trust to designate, if something happens to both of us, this is who we nominate as guardian for our children. And that nomination carries a lot of weight. And people could still contest it and say, well, siblings, adult siblings of the parents or grandparents could come and say, well, I know that person and they're no good and I want to be guardian. So there can still be a contest there, and the judge ultimately would decide who's going to become guardian. So.
Other questions, committee? This is your opportunity. Yeah, Representative Osmond, great.
Thank you very much, Madam Chairwoman. Judge Wilder, thank you very much for your presentation. I know that we spent a bit of time together on civil asset forfeiture and the Judicial Council, and I really appreciated your work there. So thank you for this. I do have a question. So my mind went to Britney Spears.
Yes.
Who was under conservatorship and broke free of that. And I wanted to find out, what is the current law for Kansas for an adult that wishes to emancipate themselves from that position? And is there any changes that are being made under this proposal?
Thank you for that question. Madam Chair and Representative Osman, again, I hate using this answer, but it depends. So if a person, so in Brittany's case, we'll use her as if she lived in Kansas, she obviously didn't have at least grave or severe mental impairment. So she could say, I want to be free of this. I want to hire a lawyer. I want to get rid of this conservatorship. If she takes action, files a motion to terminate the conservatorship, the person who had been maintaining the conservatorship would have to prove that there was still some continuing need for that she could not manage her own finances for fill in the blank reason. If the person isn't as aware and otherwise competent as we assume Britney Spears is, that's when it becomes a real issue, and that's why we're trying to make sure that there's a plan in place for what decisions the person can make, and make sure that it's very clear if there is a foreseeable end, that when that might terminate. In other cases, sometimes a family member, a neighbor, somebody steps in and says, look, I know that this has been going on, and I think conservator is probably abusing their power, and so Judge, I want to bring this to your attention. So again, sometimes it can be the person subject to that conservatorship. Sometimes it takes somebody else coming in. Guardians and conservators are required to submit an annual report to the judge. A guardian's report is about the safety, welfare, current status of the person. And one of the things that isn't in the legislation, but in the report form that we would eventually develop is how often do you see this person? So some guardians never see their person or maybe see them once a year. Is that really enough? And so we want to make sure that if the guardian in their final or in their annual report says, well, I haven't seen this person since I did my last annual report, the judge can say, well, I think we need to have a hearing on this, and I want to ask you some questions, and I may want to make further orders. So long answer to a short question, I apologize.
Thank you very much. That actually does help to clarify. So under the way that it is set up right now, though, it's established with an indefinite time period.
Yes, yes.
Okay,
Yes.
thank you.
Representative Williams.
Thank you, Madam Chair, and thank you for trying to cover all of this as best as you can, because I'm sure it's a lot. You were talking about the guardianship and giving some leeway for there to be error on their end. Can you just speak more to that and what that looks like, and where is the line in the sand when it becomes just, human fault to negligence?
One of the things that we looked at, I'm sorry, thank you for that question, and Madam Chair and Representative Williams. One of the things that we talked about and something that we have taken out of the law is restricting the guardian's ability to restrict who the person subject to guardianship can have contact with. So one of those bad decisions might be, I don't like your boyfriend, and I think he's a jerk. And so I don't want your boyfriend around. I'm going to deny you having contact with your boyfriend. As long as boyfriend isn't abusive, isn't taking advantage, the guardian maybe shouldn't do that. And so that's an area where they would need to go to the court to talk about that specific thing. Again, the boyfriend may not be the best person in the world, and guardian might choose somebody else to be boyfriend. But if that's the boyfriend the person has, again, as long as they are not abusive, manipulative, taking advantage, then that probably should be allowed to happen.
Okay, so yes, no, that answers that. I misunderstood you in thinking more from the guardianship perspective, but it's more for the person who is under the guardianship.
The person subject to guardianship can make bad decisions. Guardian should not make bad decisions.
Okay, great.
Person subject, in an effort to give them more freedom, more say-so in how their lives are lived, they should be able to make some bad decisions and not be absolutely controlled by the guardian.
I agreed with that.
Yeah.
Thank you. Thank you, Madam Chair.
Sorry, I wasn't clear.
No, that was my bad. So thank you.
Representative Vaughn.
Thank you, Madam Chair. Thank you, Judge. I was just reading through some of the new concepts included in the proposed Uniform Act, and I was curious about two things. Interested in kind of the difference between the change in the standard of decision making, so the difference between the best interest standard and the substituted decision making standard, and how those are similar or differ. And then you also kind of mentioned that as part of the Uniform Act, it encourages the use of alternatives to guardianship and conservatorship. So kind of curious how that works as those are being developed in terms of making sure that or trying to see if those less restrictive alternatives can be used. What's that process, and what are those options that might be on the table as well?
All right. Thank you. Madam Chair and Representative Vaughn, as to the first question, best interest standard, if I'm the guardian, and I'll pick on you, Representative Vaughn, if I'm your guardian, under the current law, I get to decide what's best for you. You have no say in that whatsoever. Even if you're able to have some say, I get to decide, because I decide what's in your best interest. Substitute decision-making allows me or requires me to say, well, if I was doing it, I would do it this way. But I think Representative Vaughn would prefer this, and so that's what I do. And again, not every situation is going to allow for a lot of substitute decision-making. If somebody has been profoundly and severely disabled since childhood, you're probably basically back to a best interest standard, but if it can be determined what that substituted decision-making is, that's what we want guardians and conservators to use.
That's helpful. I may be mistaken. I think we talk about that a little bit with guardian ad litems as well in terms of the best interest standard.
Right.
So it just reminded me of that, and I was kind of curious about the difference.
Right. And then as to your second question regarding other arrangements, the current act wouldn't, so the Uniform Act would allow somebody, for example, to be appointed as conservator to sell the family farm because that needs to happen for whatever reason, or sell the house just for that purpose. That mom or dad can still write the checks, they can keep the checkbook, they can do those things. But in terms of meeting with a realtor and dealing with a realtor and deciding on a purchase price and deciding what offer to take and all of those things, that's overwhelming. So we don't need a full conservatorship, but somebody's got to come in and sell the house. And so the Other Protective Proceedings Act, or portion of that, would allow for basically a limited guardianship for that purpose, or for some other judge, I don't need to be guardian, but if I could be a co-signer on the checks, just so I'm reviewing what they are. I don't, again, mom's generally okay, but, and so that's to be framed in individual circumstances as well. Again, we're trying to make a broad range of options available to meet individual needs.
Thank you. And so then under this Uniform Act, all those options would have to be considered before a guardianship or conservatorship would be allowed. Is that correct?
Yes.
Okay.
Right.
Thank you. Thank you, Madam Chair.
Representative Goddard.
Thank you, Madam Chair, and this is really enlightening to me. I appreciate your thoughts and your comments. I would imagine that whether it's a guardianship or a conservatorship, that you can get into a real sticky wicket.
Yes.
Are there provisions for periodic review by independent board or a judge or whoever to see if the best interest idea is being carried out, whether it's either one?
Yes. Thank you for the question. And Madam Chair, Representative Goddard, currently and in the Uniform Act, a judge is required every year to review guardianship, conservatorship, or guardianship and conservatorship on the same person. At this point, that is mostly a paper review. But again, if the paper indicates a problem, and that's why we want to try to beef up the forms so that the judge is aware, as I referred to previously, oh, I haven't seen this person for a year, I assume they're okay. The judge then has an alarm bell going off saying, I think we need to talk about this. And so, yes, there is a review. We hope through forms developed in support of the Uniform Act or the modified Uniform Act to beef that review up to make the guardian conservator more accountable.
So the guardianship or conservatorship parameters could be reviewed and changed.
Yes.
Now, if it comes to the point where the judge feels that there needs to be a major change, like you need a new guardian, for example, then that whole process plays out again?
Yes.
Okay.
Case, nobody would have to file a new case, but there would be a proceeding then to appoint a new guardian or a substitute guardian for the person who's no longer able.
I just wanted to make sure in my own mind that there were guardrails
Yes.
in the whole process so that the subject could be protected.
Yes.
Okay. Thank you, and thank you, Madam Chair.
Yep. Representative Carmichael, and then Barrett.
Thank you, Madam Chair. Actually, I have 3 questions. Let me ask 2 of them, then if time permits, I might ask you to come back.
Okay.
Judge Wilder, I am tempted to take advantage of your invitation of someone who's now in the well with me behind the dais.
Yes. Yes.
But out of respect to Judge Sturm, Judge Ice, Judge Walker,
Yes.
your predecessors, who taught me how to be a lawyer the hard way.
Yes.
I will not start out with, isn't it true? Don't you agree? Etc. Appreciate.
Practice in front of Judge Anderson?
I did, as a matter of fact, and I
Would
was
al-
literally sitting here thinking I couldn't remember who the other guy was.
Who would start, are you trying to tell me?
That's exactly correct.
Yes.
Yeah. Yes. I bet other lawyers have had the same experience. At any rate, Judge, I greatly appreciate the work of your committee. The members are some of the best practitioners in this area of the law that I know. I've practiced with them throughout my career, and I give your committee's recommendations the greatest of weight and deference, and I appreciate the effort. I know none of you get paid for what you do, and it's all volunteer work. Let me direct you to two areas and then perhaps come back to a third later. You discussed, perhaps, and I didn't understand it, but a change in the standard of proof, or perhaps just whatever the standard of proof would be. And I take it's in guardian conservatorship proceedings. Are you recommending beyond a reasonable doubt in all instances? And what is the present standard of proof? Help me understand that, because I never really practiced regularly in this area.
Thank you. And Madam Chair, Representative Carmichael, I was referring to the standard of proof in end-of-life decisions. We were asked to, so the current statute, which again has been in place since 2002, basically says that if a guardian feels the need to exercise either the removal or withdrawal of life-sustaining care, that they need the certification of 2 physicians, take it to a judge. The judge then can give them permission to make that decision. At this point, the current law does not require any hearing whatsoever. And there isn't specifically a burden of proof for that, that I recall. We made the burden of proof, as I recall, preponderance of the evidence, but we were asked to make it beyond reasonable doubt that this was necessary for the person. And again, our committee just said, I don't think that's even possible when it comes to an end-of-life decision.
I'm confused then. So your work product, does it provide for the judge's involvement in opinions of 2 physicians? And that would be, of course, different than the current practice?
The current practice is 2 physicians, judge signs off with or without a hearing.
Mm-hmm.
The recommendation for change is, yes, you still need the recommendation of 2 physicians, but there also has to be a hearing. The person subject to guardianship has to be represented by counsel, and the burden of proof is clear and convincing.
I'm perhaps
sorry.
more lost than I was.
That's what they were asking for, clear.
They asked for beyond reasonable doubt.
Okay, all right. And but you did put in clear and convincing as the standard in the recommendation? Or preponderance?
I'll have to look.
Okay. Okay. So anyway, there now is a standard and there has to be a hearing. That's what the bill's going to say that we get next week.
Okay, well, I'm still very lost on that point, but we can explore it next week, hopefully within only 2 questions. But their response does lead the segue to my second question, with your leave, Madam Chair. We have had discussion in this legislature for several years about a concept of assisted decision-making, something perhaps short of power of attorney, durable power of attorney for healthcare decisions, limited powers of attorney that impact end-of-life decisions, particularly when the subject of the power of attorney is incapable of making their own decisions, but it's durable in nature. Can you address any consideration that the committee may have given to this, what I believe would be a lesser standard that concerns me, of assisted decision-making, and how that works into what we have now with I think what's going to be limited scope conservatorships or guardianships, et cetera. Could you just help me with that conceptually?
I'll try. The committee had another issue or another proposal that has been submitted to the committee, but we have not begun review, is proposed legislation on supportive decision-making. So we've done nothing on that particular issue. Our work was just in reviewing these two uniform acts as they relate to Kansas law. We didn't, as I recall, we don't have any type of supported decision-making legislation currently, or nothing in the books, and so we didn't feel like there was anything to draw on, and we wanted to limit what we were doing, but we've been given a new assignment to look at that.
I appreciate that. Madam Chair, if time permits, I want to ask about impact on third parties like bankers, but we'll see how that goes.
That's good, because I'll just give the committee a reminder. Last year, those who were still on the committee, we had a hearing on supported decision-making. And it didn't, we didn't work the bill, but instead, we had lots of the bankers, especially opponent testimony. And we, Representative Lewis and I asked the Judicial Council to take a look at that. And I think that since has gotten sent to your committee to take a further deep dive in. So that's kind of where that supported decision-making came from. and
Madam
where it
Chair,
is.
Nancy Strauss just advised it is clear and convincing.
Clear and convincing, okay, thank you. Okay,
Sorry,
On
clear and
end of life.
convincing for
on
which?
end of life.
Thank you.
Representative Barrett.
Thank you, Madam Chair, and thank you, Judge. It sounds like there's some much needed improvement here. I guess and this is coming completely as a novice to this. From the law enforcement side, I know when we've responded to calls, usually to the elderly, maybe there's some cognitive decline. And because of that, they're falling victim to romance scams and they forget about it, or they're falling victim to other mail scams. It could be anything. The tools will still be there with these recommendations where you can restrict those transactions, correct?
Absolutely.
Okay, I just wanted to clarify that.
Yes,
Thank you.
Absolutely.
Yeah, good question. Okay, committee, any other clarifying questions or anything? Okay. Oh, I'm so sorry. Oh, forgive me. Yes, we do have time. Please go ahead.
Thank you so much, Madam Chair. I appreciate your courtesy. I think one of the proposals that the committee has is, for example, conservatorships with a limited scope. I think the example you gave was for a transaction involving the sale of real property. What protections or do we have for third parties who have to rely upon the authority of a conservator who only has a limited scope? Is it going to show up in their conservatorship paper and specifically, or I know there's going to be a guardianship plan. Is there a similar plan on the conservator side? How deep does the banker have to dig is a simple way to put it.
Madam Chair and Representative Carmichael, I believe the intention is that the order that comes from the court would be absolutely clear about those limitations and what the person is or is not granted authority to do.
Perfect. Thank you, Madam Chair.
Okay, sorry, forgot about that. Okay, anything else, committee? I do have one clarifying question that Representative Vaughn asked. The new bill requires a look at, are there any less restrictive plans? So for instance, I've done a conservatorship for a guardianship for a 17-year-old. The parents wanted they were going to turn 18 and they needed a guardianship. So would I have to, in the petition, have to show we've tried, we've thought of this, we've gone through this, but now we think guardianship is the best? I mean, what is there new forms or how's that going to work?
Thank you, Madam Chair. We don't have new forms yet because we wanted to get the statute in place if that's going to happen and then work on forms. But the idea would be that there is at least some description of other alternatives. I realize if somebody wanted to be obtuse about it, you could list every possible thing you've ever thought of, and can we give them a piggy bank? No, that won't work. But the idea is that you give some reasonable explanation of reasonable alternatives that you've considered. So I'm going to take it away from the teenager and go back to the older person. Judge, we have tried having somebody just be with mom when she's writing the checks, and then we find that she writes checks beside that, and so she's actually overdrawing her account. And Judge, then we tried kind of taking the checkbook away so that we could do it all together, and she ordered more checks. And so, and this has been the result, and she's consistently overdrawing the account, so that you show this is what we've considered and this is why it's not working. Not asking you to write, you know, a 30-page motion, because you also have the hearing in which to present that evidence, but you would at least outline, we've considered these other things and nothing is working.
Okay, thank you.
Yeah.
Okay, committee, anything else? All right, thank you so much for that great explanation and presentation. I think it will help us tremendously next week when we do have our hearing. And yeah, we will have we'll have some other proponents next week on this bill. And I think there'll also be some neutrals that have some suggested amendment language is what I'm thinking that we're going to hear about. Okay, 4:35, good job. So I just want to let you know, tomorrow we have a hearing on House Bill 2173. I don't think we have a whole lot of conferees yet, or so far, but there'll be some. We also are having this sort of same informational hearing on a bill that we will have next week that updates the LLC Act. Another riveting, exciting topic for the Judiciary Committee. But I think you will find it interesting. It might not sound like it, but when you get into it, I think it'll be interesting. But it's also a large change that we're doing, kind of an update. And so having this informational hearing tomorrow, since we don't have the bill number yet and it's not completely finished, it'll again give us the ability to expedite the hearing next week when we do have that. And I'm still waiting for a few other bills to come in that we know we'll have hearings on. So you will see that your agenda for next week is very wide open. I mean, I am still of the intent of trying to not have committee meeting on this Friday or next Friday, but not making a definite plan on that yet. Tomorrow, I do plan to work House Bill 2182 and House Bill 2166. And with that, I think that's it. Anything else for the good of the committee? Yes.
I'm very bad about memorizing bill numbers. Do you happen to know the topic of 2182 and 21?
Sorry, 2182 is the one that we heard yesterday that there's no fee to do the protection order. And then 2166 we heard on Monday, and that was just the annual open records exceptions. So two easy ones. Okay, thank you, everybody. We're adjourned.